Our scenario was based on a situation where a female teacher was putting off sexual advances from her male principal for 2 years. She eventually began to respond to his romantic suggestions, and they would meet at hotels and each other's homes when his wife was away. The district eventually found out about this sexual relationship and offered them both a transfer to other schools, but they both refused. After refusal, the principal and the teacher were released from their positions and sued the district. For this case, I will be acting as the defendant and supporting the decision of the district. Let me first start with the sexual advances that the principal placed on the teacher. The teacher should have immediately reported this situation to the district. Title IX of the Education Amendments Act of 1972 requires schools to establish a policy against discrimination and to adopt and publish procedures for resolving discrimination complaints. This includes complaints of sexual harassment. The school made sure that students, parents, and employees all knew about these policies and procedures. This district does have a policy in place, and the teacher should have reported the principal. She was required to take a staff development course, watch a video, take a quiz, and sign a form stating that she understood these policies. Although she was familiar with these, she chose to disregard them and allow the sexual advances to continue, which in turn allowed the principal to keep his position. The teacher is also familiar with the term hostile environment sexual harassment, which is sexual harassing conduct, which can include sexual advances, requests for sexual favors or other verbal, nonverbal, or physical conduct of a sexual nature that is sufficiently severe, persistent, or pervasive to limit the teacher's ability to participate in her school environment. I would consider 2 years of harassment to be severe, persistent, and pervasive. In Moberly versus Mid-Continent Communications in 2010, a supervisor's comments to an employee that he was attracted to her and wished he could spend the entire day with her were sufficient enough to demonstrate unwelcome harassment in the form of sexual advances. The teacher also had sufficient evidence over the past 2 years to demonstrate harassment, as her case was similar to the one stated above. Once again, she chose to disregard this harassment and allowed the conduct to occur without reporting it. Employers, such as school districts, can be held liable under Title VII of the Education Amendments Act when a supervisor harasses an employee when certain criteria are met. In Fogarty versus Boca Raton in 1998 and Burlington Industries versus Ellerth in 1998, the Supreme Court established the standards that govern the liability of an employer for sexually harassing behavior of a supervisor towards a subordinate employee. An employee is subject to vicarious liability under Title VII for an actionable, hostile environment created by a supervisor with authority over the employee. According to Burlington Industries versus Ellerth in 1998, a supervisor is one empowered by the company as a distinct class of agent to make economic decisions affecting other employees under his or her control. The immediate supervisor for teaching staff members may be a building principal, a member of the school district's non-instructional supervisory staff, and or the school business administrator or school board secretary. In this case, the building supervisor was the teacher's immediate supervisor. The district is claiming quid pro quo. Quid pro quo sexual harassment is when a school employee explicitly or implicitly conditions a teacher's participation in an educational program or activity or bases an educational decision on the teacher's submission to unwelcome sexual advances, requests for sexual favors or other verbal, nonverbal, or physical conduct of sexual nature. Quid pro quo harassment is equally unlawful whether the teacher resists and suffers the threatened harm or submits and thus avoids the threatened harm. In this case, the teacher submits and receives less duties, higher level students, and excusal from staff meetings and department meetings. She is also not placed on any after-school committees. Every other staff member in the school is required to have at least 2 duties, at least 1 committee, and mandatory attendance to all staff and department meetings is required. Appropriate comments include, but is not limited to, comments of sexual nature, sexually oriented humor or language, inappropriate comments about the teacher's clothing or physical appearance, comments with sexual overtones, comments regarding a dating partner, or comments about the staff member's personal life that are not relevant to the professional responsibility of the school staff member. In written affidavits completed by staff members at the school, it is stated that the principal has been heard making sexually inappropriate jokes to the teacher, making comments about the teacher's clothing being too revealing, and discussing with a friend of his at an after-school event how good she is. The principal's school-issued computer has also been searched. The district has found inappropriate inappropriate graphic images as well as emails describing what sexual things he wanted to do to her after school. South Carolina Code of Law, teachers have standards of conduct to follow. These codes of conduct are placed in the school handbook, online, and on the state education website. The code states that revocation of your license or suspension of employment may occur if the teacher is portraying unprofessional conduct, immorality, dishonesty, and/or conduct involving moral turpitude. In this case, all of the above have been breached and depict unprofessional conduct. The district did receive signed affidavits from 3 other witnesses that knew the sexual relationship was occurring, and one from each of the 2 plaintiffs acknowledging the alleged misconduct. According to the district policies and procedures, any teacher who fails to comply with the provisions of his or her contract without the written consent of the school board shall be deemed guilty of unprofessional conduct. Upon the formal complaint of the school board, substantiated by conclusive evidence, the state board shall suspend or revoke the teacher's unemployment. In an effort to save the principal's and the teacher's job because they are both widely regarded and revered both by educators and parents of children in the school as an outstanding principal and teacher who have both performed superbly, the district did offer to transfer the teachers to different schools. The principal and the teacher both declined the offer and lost their jobs. According to the United Federation of Teachers, failure to follow an administrator's directive could be considered an act of insubordination and could lead to disciplinary actions against you. The 2 were insubordinate and did not follow directives given by the school board, therefore resulting in their unemployment. The directive did not violate the contract, as the contract states that an employee may be moved to a different position at any given time. Copies of each contract signed by the plaintiffs have been provided to the courts.